sentence that a judge could deliver.
One thing that I would assume a defense attorney would want to do is make the jury like their client. It didn't seem there was animosity directed in this. There wasn't that hatred built in for this particular defendant, although it was as if the prosecution was really just trying to prove how negligent he was. They weren't painting him out to be some bad guy, were they?
Well, you know, I think to a certain extent they did try to demonize him again through Dr. Schaefer with these 17 points of misconduct. And also in the closing argument, the prosecution made a big point of Michael Jackson's children and the significant loss that they've sustained as the result of his death. So, you know, they tried to create tremendous sympathy. However, having said that, I think you look at Dr. Murray and you know he's going through agony. He does seem like he's a nice guy. You heard from his other, some of his other patients who say, you know, this guy, he's not a money-oriented guy, even though the prosecution tried to paint him as that. And he would do a lot of good things for his patients and, you know, sort of go above and beyond for his patients. So I think the general sense, his persona, is that he's a decent, nice guy who made a terrible mistake here.
Do you think that resonated with the jurors to have the defense talk about Michael Jackson's children?
You know, for me, I thought it was actually a low blow to inject the kids into this thing when the judge says you're not to allow sympathy or prejudice or compassion enter into your deliberations. You know, what did the kids have to do with this case? Not a heck of a lot. So to inject them into the closing argument, I thought was sort of unfair.
Well, and as you said, there was a measure of piling on to a degree, because when it's cut right down to it, the prosecution really they didn't have to show intent to kill Michael Jackson. And if you remove that burden from them, it seemed as if they could have done less and almost achieved more.
Exactly, but the LA County District Attorney's Office, you know, has lost some big cases. So they were really, once again, engaged in overkill, trying to leave no stone unturned to get a conviction on a big case and not sort of suffer the consequences of yet another not guilty.
Now, when the verdict comes down, if it is not guilty, he'll be let free. If it is guilty, he can be either remanded to custody, he can have probation, or discuss some of those options. Yeah,
I think what's going to happen is, let's assume it's guilty for the sake of discussion. The lawyers are also going to perhaps want to talk to the jurors. They're going to want to regroup and sort of see what's the next step. So I think the judge is going to give a brief recess or timeout, so to speak, before they have a discussion on whether Dr. Murray should be remanded. Additionally, it's quite possible that that discussion has already taken place between the prosecutors and the defense attorneys and maybe even the judge. Hey, if it's a guilty, Your Honor, do you intend to remand Dr. Murray? If so, you know, we'd like to be heard. And, you know, they'll sort of set out some sort of choreographed aspect to what's going to happen once the verdict is read. If it's a not guilty, hey, you know, all chaos breaks loose and everybody goes their own ways, and Dr. Murray breathes a huge sigh of relief.
We're getting word now that Dr. Murray is just preparing to go into the courtroom, that he is, in fact, at the courthouse, and that his mother is with him. So at this critical moment, as you mentioned before, having been with so many defendants, this moment is so gut-wrenching and nerve-wracking. He has chosen his mother to be with him, and she will be in the courtroom with him when the jury announces its verdict. And we, again, are expecting that verdict to be read at any moment. You're looking live at the seal in the courthouse, or in the courtroom. The verdict was reached this morning. They deliberated in less than 9 hours. And whether it is not guilty or guilty, we will find out very shortly. It was supposed to have been read right around 1 o'clock.
Dana, what advice do you give to your clients when they're defendants and a verdict is about to be read? What advice do you give to them?
Great question. I basically say steel yourself, hang tough, don't worry. There are always options. If it's a guilty, we can always appeal. Just hang in there. We'll get through this.
We're also getting word, along with his mother, Nicole Alvarez, the mother of one of his children, has also arrived with Dr. Murray. So he is trying, it seems. I would assume this is another thing as a defense attorney you would want, is to make sure that he is surrounded by the people who are closest to him.
You really need that support, not because it's something that you want to orchestrate for public purposes, but because it's the right thing to do. It's a scary moment, and you want to have your loved ones near you because you frankly need that type of emotional support for this type of moment.
And you'll recall that Nicole Alvarez, she was a witness in the prosecution's case. They called her, and she's his current girlfriend. She is the mother of one of his children, and remember, she described her acting duties as taking care of my instrument, motioning to her body. It was very memorable when she was on the stand.
And definitely the line of the trial, although it didn't mean much, but definitely it's something that everybody's latched on to.
Dana, obviously we don't know for sure, but having been a defense attorney for these many years, what are we waiting on now? All of the players, we're told, are now in the courtroom. Obviously not the judge, Pastor. So what are we waiting on at this point as we continue to look live at the camera in the courtroom, focused on the seal?
Well, it's quite possible the judge is sort of bracing himself, for what's going to happen and, where we go from here as the world is sort of watching. So he may be collecting his thoughts and thinking about what he might want to say to the jury once the verdict is read, because he's going to go through a bit of a speech and thank them. But I'm sure he's going to do it in an interesting, unorthodox way, because this is an interesting, unorthodox trial.
And he knows everybody's watching him. And he has done any number of high-profile cases before, but he is well-respected. He is very detail-oriented judge. But to me, as you were just mentioning, given this trial, given this focus on this particular verdict right now in this courtroom, this is a good judge to have there. He's been through a measure of this before.
Very experienced judge, without any question. And, he ran a pretty good trial, you have to say. In a sense, it seemed that he was tilted more toward the prosecution at various times, but that just may have been the correct rulings of law that favored the prosecution. But he is very experienced, and he's a good guy to be in that seat, for this type of moment.
Now, as we wait for this verdict to be read, a little bit about what the jurors do. They do not discuss the case until deliberations begin. They go into the deliberating room, and do they immediately take a vote and just start, or do they have to go through evidence? What happens?
Right, the judge actually instructs them not to lock in to a particular position at the beginning of deliberations, because then oftentimes it's difficult to change your mind, and you sort of get locked in, and you feel like you need to justify an early statement of your belief. So he encourages them not to do that, and hopefully most jurors, follow the instructions, take the judge's advice. Sometimes you'll have a bully juror who will immediately announce a position and then bully people into trying to come to that position. But I don't think that's the case here. I think there was a lot of vetting of these jurors, and it's a good amalgamation of personalities and people and occupations and intellect. I think Dr. Murray, whatever happens here, definitely got a fair shake from this jury.
Speaking of what might happen next, if he's acquitted, the prosecution can't appeal. If he is convicted, he only faces maximum of 4 years in prison, and we have discussed with you that that's not likely to get. So what would be the benefit of an appeal, even though he would have legal justification and he could appeal? That could drag on longer than his sentence.
Oh, without any question.
Would you just advise someone at that point, just take your lumps and be done with it?
Not necessarily. If there are true grounds to appeal, then by all means you have to pursue that appeal. Also, reputation is at stake. Even if he could get through the jail sentence, or if he gets house arrest or something like that, can do that standing on his head. But it's the reputation that has suffered a huge blow, and that may be an impetus for an appeal.
Looking at this case right now, do you see any glaring ground for appeal?
Well, I think there was one decision that the judge made where he wouldn't allow, he had, I'm blanking on what he didn't allow the jury to hear regarding Dr. Murray's lawyers wanted to present some sort of evidence.
There was the other doctor, Arnie.
It was Dr. Klein.
Yeah, was that the case?
Some other doctors. I think there was some other evidence, and it'll come to me in a minute.
It always does.
Right, if we ever get to that point, I'm sorry. But,
so there was something.
But the point, I think, is in any trial, nothing is perfect. You know, there are always grounds to appeal anything. Frankly, my thought is injecting the kids in the closing argument by the prosecution, I thought, is an appealable issue.
But don't you have leeway in a closing argument? Don't you have leeway? You can inject, you can be very persuasive and very dramatic?
Well, you definitely have leeway, no question about it. And but I don't think I heard any objection from the defense when the prosecution was talking about the kids. So if there was no objection, arguably that's
kind of hard to appeal something that you didn't object to.
Right, that's way.
Because when you're in your closing arguments, you're only supposed to discuss things that were presented at trial. You can spin your version of them, but you really can't bring things in that weren't presented, correct?
Absolutely. But primarily, the appeal would be based upon rulings that would have precluded evidence or would have allowed evidence that would be highly prejudicial or not relevant, something like that. So, you know, one has to sort of go through the evidence with a fine-tooth comb to make those decisions.
We are looking into the courtroom now. You see that the judge is there. We're going to listen in, and again, we don't know what the verdict is yet, but we are about to hear the verdict at any moment.
Face the flag of the United States of America, recognizing the principles for which it stands. Department 107 of the Los Angeles Superior Court, State of California is now in session. The Honorable Michael E. Pastor, Judge presiding. Please be seated.
This is the case of People versus Conrad Robert Murray, case SA 073164. Dr. Murray is present in court with counsel, Mr. Chernoff, Mr. Flanagan, Mr. Gorgian. The people by counsel, Mr. Walgren and Ms. Brazil. All alternates are present. All regular members of the jury are present. To everybody, good afternoon. Ladies and gentlemen of the jury, I am advised that the jury has reached a verdict. Who is the foreperson of the jury?
I am, Your Honor.
Juror number 3? Thank you, sir. Is that in fact correct?
Yes, it is.
The jury has reached a verdict.
Yes, it is.
Has the jury, through the foreperson, signed the appropriate verdict form?
Yes, sir.
Do you have all the verdict forms with you?
Yes.
Could you provide the verdict forms to Deputy Jones, who will then present them to me? Thank you. The court has reviewed the verdict form. And, ladies and gentlemen, there was a typo in terms of the date of the alleged incident. It was written June 9th, 2009. And juror number 3, you've corrected that to June 25th. You put a 2-5 and you put some squigglies after that?
Yes, sir.
All right, thank you. I've reviewed the verdict form, which now I will pass to Mrs. Benson, the court clerk. Mrs. Benson will publish the verdict.
Superior Court of California, Los Angeles County. The people of the state of California plaintiff versus Conrad Robert Murray, defendant. Case number SA 073164. Title of court and cause. We, the jury in the above entitled action, find the defendant, Conrad Robert Murray, guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192, subsection B. Alleged victim, Michael Joseph Jackson. Alleged date of June 25th, 2009. As charged in count 1 of the information. This 7th day of November 2011, four-person juror ID number 145, seat number 3. Is this your verdict? Is this your individual and personal verdict? So say you one, so say you all.
Yes. All jurors indicating the affirmative. Ladies and gentlemen, I'm going to ask you whether this is your individual and personal verdict. I'm going to be asking you individually if this is correct. If it is your individual and personal verdict, say yes. If it is not your individual and personal verdict, say no. Is this your individual and personal verdict, Juror 1?
Yes, sir.
Juror 2?
Yes, sir.
Juror 3?
Yes.
Juror 4?
Yes, sir.
Juror 5?
Yes.
Juror 6?
Yes.
Juror 7?
Yes.
Juror 8?
Yes.
Juror 9?
Yes.
Juror 10?
Yes, sir.
Juror number 11?
Yes.
Juror 12?
Yes, sir.
All jurors having indicated in the affirmative, the court clerk is directed